Welcome back to this final segment of this human rights law session. Now, before the break, I said to you we'd go straight into Article 6, and therefore, without much further ado, let's do that. I will, for the third time, remind you that you should not get your Article 6 mixed up with your Section 6. It really could be fatal. Now, Article 6 is what we will consider here. Remember, Section 6 dealt with public bodies, and we looked at that. With Article 6, it looks at a right to a fair hearing. Now, this convention right is more commonly referred to as a right to a fair trial, and it forms an integral part of the common law reasoning when one looks at the criminal and justice processes, and certainly when you seek to assess justice as a subjective concept, particularly when you're looking at legal aid and where that is concerned. Again, if you remember the whole McLibel case, the point there was it's an Article 6 issue because a right to a fair trial, you've got McDonald's and all their money on the one hand, and these persons who were said to have defamed McDonald's. So the idea is looking at a right to a fair trial. Now, when you look at this particular era, it can, again, legitimately have a question where if an examiner comes in a very narrow confine, he could ask you a question just on this in the context of the HRA, and you need to be prepared. Now, the right to a fair trial is more or less an essential right in all countries which of course respect the rule of law. Now, you must know and understand the elements of this article in order to be able to expound on it, and in particular, you should be able to reason it and look at it from various aspects, not least when you look at miscarriages of justice, for example, and the whole idea of due process of law, when you look at jury trials, when you look at the civil justice process, when you look at reforms, in particular alternative dispute resolution, and when you look at legal aid. All of these have an impact in relation to a right to a fair trial. Because again, that's one of the reasons when, for example, you look at, these juryless trials being advanced, the idea or one of the criticisms and one of the resistance to it is that, well, are you going to have a case-hardened judge sitting in your matter? And that, of course, has implications for the right to a fair trial. Now, in the determination of civil rights and obligations, or in respect of any criminal charge against a person, everybody is, of course, entitled to a fair and public hearing. Now, it should be brought, of course, within a reasonable time. It must be brought before an independent and impartial tribunal, and this includes a court or panel which is established by law. Now, everybody charged with a criminal offense should, of course, be presumed innocent until proven guilty, according again to law. Now, there should, of course, also be provisions for free assistance of an interpreter if you cannot understand the language in the trial that you are being adjudged in. Judgments should be pronounced publicly, but the press and public may be excluded from all or part of the trial if, for example, there are issues which are particularly sensitive. Now, this has given rise in recent time to some questions. For example, when you have children in cases of rape, or children when you have cases where there's been molestation, because, on the one hand, you have to balance this, for example, a defendant's rights insofar as he should be able to question his accusers, meaning his lawyer should be able to question them, and of course that sympathetic interest in relation to the child. But again, if someone is in a position where they are being, where an allegation is brought, then there is this idea that he should have that right. Now, there's a right to the attendance and examination of witnesses and legal representation. Again, I said with legal representation, the idea is that if you cannot afford legal representation, should it be the state's business to assist you with that? Now, in the case of Benham and the UK, the European Court of Human Rights decided that the defendant was entitled to legal aid and held that he did not have a fair trial because he did not have legal aid. Now, should Article 6 be a limited right or a fundamental right? Now, to end on that point before we go into the next point I want to raise, is I want to leave something for you to think about in relation to this. When you look, for example, at the EU framework, remember I said to you that the European Convention on Human Rights is a separate framework. When you look at the Charter of Fundamental Rights, we see that it sets out certain basic rights which you're entitled to. When you look at the Charter of Fundamental Rights, or even when you look at the United Nations declarations on human rights, you see that it gives basic rights. Here with the Human Rights Act, it seems to give arguably political rights. So does the right give you a basic right to a standard of living, a basic right to healthcare, a basic right to education? Basically, does the human rights give you basic rights, human rights? It is a point for you to ponder and certainly for you to raise. What we will finish off though is, what has the Human Rights Act done? Has it given the UK a Bill of Rights? Well, we have a problem with that, because when you look at Bill of Rights, and I take you back to where we started in the first segment of this law session, we see the US, we see Canada, we see South Africa, we see other states where they have a Bill of Rights entrenched in relation to the rights of the citizens. In the UK, we have no more than an Act of Parliament which tomorrow can be repealed, and arguably it appears that human rights in the UK stands on a very tenuous basis. It could be washed away tomorrow. Should there be a Bill of Rights, meaning something that is entrenched and firm? But even if there is, how would it come about? Are you looking for it to be a referendum? Is there any mechanism in the UK's uncodified structure? Should it be considered along the lines of constitutional acts like the the ECA, the European Communities Act? But even that again can be repealed. The idea is that when you look at a Bill of Rights, is it time that the UK has a Bill of Rights, or is the flexibility of the uncodified constitution such that the UK, taking the position it has always taken, that, well, we've always been guardians of human rights and therefore we don't need a Bill of Rights to tell us what to do. We are a nation of right-doing people. Is that the point? Well, when we look at David Cameron, the Prime Minister, he had vowed to repeal the Human Rights Act if he was elected. Well, we still await. Instead, he said he would replace it with a Bill of Rights for Britain. Now, after the 2000 general election, of course, we see that the coalition government saying that the issue will be investigated. And around about 2007, we see the human rights organization Justice releasing a discussion paper which says, should there be a Bill of Rights for Britain? Now, it is really for you to examine and look at whether a Bill of Rights ought to be in place, and if it is, what is the basis that it will take? Because one of the points as well is when you look at Article 15 and this whole idea of derogation, does the Section 14 of the HRA go too far, or does it go further? Now, we see that certain senior Labour politicians in recent times have criticized the Human Rights Act and the willingness of the judiciary to invoke declarations of incompatibility against, for example, terrorism legislation. Now, when you look at other kind of criticisms, there's this idea that it is hampering the fight against global terrorism in regards to controversial type orders. Now, it is a balancing exercise. It really is. Do you compromise persons' rights in a way where there's this climate of fear? So every time you see somebody you think might be a terrorist, you think that his rights ought to be washed away, as it were, and you can trample all over it. There's that one argument. Or is it that there should be a situation where, yes, the government is given some more powers if it thinks that other citizens need to be protected? It is a fine line and really one for you to make a discussion on. Now, as I say, when you look at Section 4, all it provides for is a declaration of incompatibility. So it really is not for a court to strike down any kind of legislation. One of the points that you must bear in mind is that there are two other sections of the Human Rights Act which are very important, Section 10 and Section 19. Now, in particular, when you look at Section 19, it does by and large preserve the whole parliamentary sovereignty framework. Section 10 is a fast track option that can be used by ministers to amend non compliant legislation. So if there's a piece of legislation currently that is non-compliant to the HRA, Section 10 allows for it to be complied with. Now, Section 19 requires that for every government bill, the minister in charge of the House should make a statement that in his or her view, the bill, the HRA's, the bill that is before Parliament, that it complies with the HRA's provision. That said, it is, frankly, Section 19 does not mean again that there's any soft form entrenchment. It simply means that a statement must be made whether or not it complies with the HRA. And it really should be in the early stages of a bill that this is dealt with. So they must personally sign a statement, the terms of the statement being set out also in the Act to say, well, whether it complies or not. The point, of course, being that when you look at the HRA, there are certain important sections that that you need to know. And as it relates to Section 19, certainly as it regards private members' bill, you certainly don't need the Section 19 statement. So do bear in mind you need to know Section 2 of the Act, Section 3 of the Act, Section 4, Section 6, Section 8, Section 10, Section 19. Those are very important to note. Well, what about contemporary issues? There have been some recent issues which no doubt impact on human rights. One that springs to mind is this whole saga with Abu Qatada and this gentleman who keeps resisting his deportation back to Jordan because he says his human rights cannot be guaranteed. Now, has it all gone too far? Can the UK withdraw, for example? So this idea of Abu Qatada is one to consider. The other, of course, is when you look at the UK's position when it comes to prisoners having the vote. Well, there's this blanket ban in the UK now. When it is raised, everybody looks at it as somewhat abhorrent. But the UK across Europe is the only country who says, well, if you're in prison based on the Representation of People's Act, it says, well, you can't. Prisoners certainly don't have the vote. There's this blanket ban. Now, there are certain options that the UK has, and one, of course, is to lift the ban entirely. The other, of course, is to say, for example, there are certain persons who can vote. So let's say, for example, somebody who is serving less than a 6-month sentence, somebody who's serving less than a 4-year sentence. They can actually put a qualified framework in place, but to say that a prisoner does not have the right to vote, case for you to look at, because of course this was brought about by persons who, frankly, prisoners who had a lot of time on their hands to think about it. Look at the case of Hirst and the UK, HIRST. It is one that shows you where this is likely to go. And in recent times, we have seen the coalition government being very intransigent in allowing this. The problem, of course, is if they keep continuing to say, no, we're standing by, we will not allow it, and therefore we're standing by the blanket ban, it may very well be that it is the taxpayers who pay. So if it is that the ban remains, then it may be popular with voters insofar as don't allow them, but it may also prove expensive. If it is as well that they allow them to vote with no ban whatsoever, so everybody in prison has the right to vote, then it may very well be that it proves an unpopular political matter when it comes to elections. Again, you have to look at it contextually when you consider human rights. So That brings us to the end of this law session on human rights, and I sincerely hope that you will join us for the next law sessions in this series of public law.